This conference will now be recorded.
So welcome to today's topic of top 5 legal insights to empower you to navigate through COVID-19. Today, I'm very proud to be co-presenting with my colleagues, Alan Dans, Ken Miller, Ido Alexander, and Nancy Brodsky. So first, I'd like to introduce each one of our co-presenters. We have with us today Alan Dans, an employment attorney, and Alan is the partner of a boutique labor and employment law firm. He has been given the highest rating that an attorney can earn through Martindale-Hubbell from his peers. And Alan serves on the board of directors of the Broward County Bar Association. Welcome today, Alan.
Thank you.
Our next co-presenter is Ken Miller, and Ken focuses his practice in the area of medical malpractice. He is a partner at the law firm of Halitzer, Pettis, and Schwab, located in downtown Fort Lauderdale. Like our colleague Alan, he has also received and earned the highest AV rating through Martindale-Hubbell. And Ken has 25 years of experience representing doctors and hospitals and now consumers. And one of the things that Ken is most proud of is that he has been recognized as one of the best lawyers in America. So welcome, Ken.
Hello.
Our next co-presenter is Ido Alexander. Ido specializes and focuses his practice on reorganization and bankruptcy. He's also very proud to have earned the AV rating. He has been cited as one of the best lawyers in America, and he is the former president of the Bankruptcy Bar Association of Southern District of Florida. In his practice, Ido represents debtors, creditors, as well as bankruptcy trustees. And he is a founding partner of the law firm of Lederman, Shellameth, Alexander, and Somadevia. So welcome, Ido.
Hi, everybody.
We're also joined today by Nancy Brodsky, who I've known for many years, and I've had the pleasure of co-presenting with Nancy at a Broward County Bar Association event. Nancy specializes in collaborative family law as well as family mediation. And she focuses in her practice on creating solutions for LGBTQ families, including issues surrounding adoption and surrogacy. And she has been recognized as a leader in the legal battle for marriage and divorce equality and LGBTQ rights. Welcome to our panel, Nancy.
Thank you. Good to be here.
And I will be serving as your moderator today. For those of you who don't know me, I'm board certified in elder law. That has been my specialty for 29 years. And my practice is not limited to working with older individuals, but actually individuals, couples, and families of all ages, helping people find the right solutions to their personal aging issues. And I do love to advocate for people with disabilities and the LGBTQ community. So the last 6 months has been a very trying, challenging time in everybody's life, both personally as well as professionally. We've seen that the impact of COVID-19 has had far-reaching effect. It's affected the financial markets, consumer debt, It's affected employment, as you can see from the graphic on the PowerPoint slide, what has happened to the unemployment rates in the US and in Florida. It's most definitely impacted people's relationships with other individuals, with friends, with families as a result of the quarantine. We've seen a direct impact on the availability of healthcare. Unfortunately, many people who have lost their jobs have been challenged with the question of, how am I going to pay my rent? How am I going to pay my mortgage or my utilities? And we've definitely seen an uptick in abuse, neglect, and exploitation as a result of people being alienated through the quarantine. So people are looking for answers to their questions. How do they plan for their future? How do they get through this challenging time? And where do we go from here? So today, we're going to have our panel share with us the concerns they're hearing from clients. What are some of the solutions, as well as recommendations, to help people navigate in this new environment? So we're going to get the opportunity to hear from each panelist, and I'd like to start with Alan. Alan, what have you been seeing and hearing in the last 6 months? What are the concerns? What are the common questions you're hearing as your clients are trying to not just get through, but actually survive and come out on the other side?
Stephanie, good question. And that's been an issue that has evolved over the last 6 to 7 months as these challenging times have evolved with the pandemic. So initially, back in March and April, when there were a number of state and local quarantine orders, which impacted primarily the non-essential businesses to be closed, employees to be furloughed, employees to be laid off. You know, the nature of the questions that I was receiving primarily from clients had to do with, you know, I'm either going to have to, the non-essential businesses at least, how do I lay off employees? How do I furlough employees? How do I do that without running afoul of the various state and federal discrimination laws if I'm not laying off all of my employees, but just some of them? That particularly was more relevant with some of the essential businesses that remained open. And that has evolved over time to the issue now of businesses are back open. Essential and non-essential businesses have, for the most part, reopened. There's still certain exceptions, but most have reopened. And now the issues range from, how do I bring back my employees in the same way that I'm not being discriminatory? And then it also goes to questions relating to, I want to bring back my employees, but I have employees who don't want to return for a variety of reasons. And that implicates various laws, such as the slide that you're seeing in front of you, the Families First Coronavirus Response Act, and how that interplays with employees who may or may not want to return to the office.
So what do both the employer and the employee need to know about this Family First Coronavirus Response Act?
Well, I think first of all, what's so important under any circumstances, whether it relates to this act or any other law, is the availability of open communication between employers and employees. That usually, or the opposite of that, is usually what creates problems, the lack of communication. So if employers and employees are communicating with one another and interacting and engaging in this sort of interactive process to determine how an employee may or may not be able to be accommodated, that's essentially important. With regards to the Families First Coronavirus Response Act, you know, that is new law that kicked in on or about April the 1st of this year, was passed in March. It's going to be effective at least right now through December the 31st of this year. It may be renewed after that, depending on where we sit with the pandemic. But I think what's really important to know is when an employer is required to pay an employee under various circumstances when an employee cannot return to work, either because there's another quarantine order in place, because the employee may have symptoms of COVID-19 and may need to be tested for that. Or, for example, an employee has a minor child or an adult child with a disability that cannot care for him or herself, and the school, daycare center, or care facility for a disabled adult is closed as a result of COVID-19, and what obligations the employer has to provide an accommodation under the FFCRA for those employees under certain circumstances.
So tell us more, because I definitely in my practice see that my clients are challenged by being split in many different directions. They're trying to keep a job. They have to take care of a young child, or they've become a caregiver now full time for an older adult in the family. So how does the Act help those people?
So, of course, this act we could spend the entire hour talking about, and of course we don't have the time to do that. But for example, if a school is closed and an employee has to care for their minor child, or again, disabled adult child, and a school or daycare facility is closed still because of COVID-19, then this act allows for the employer to provide that employee, assuming they can't telework, they can't work from their home for whatever the reason, and there's work to be performed, then the employee is entitled to up to 12 weeks of leave. The latter 10 of those 12 weeks are paid at 2/3 of the employee's regular salary or wages. The initial 2 weeks, which are typically unpaid, the employee can use if there's PTO, paid time off, vacation, sick time that the employer provides, can be used for those first 2 weeks as well. So that's one huge benefit to an employee that has to stay home and care for their child or disabled adult child. And of course, I don't want to scare employers about that, because that sounds like a lot of money to have to pay for 12 weeks. The reality is, and the good news is that this particular act allows for every employer to be made whole by taking all of those wages or salaries that are paid to the employee and allowing the employer to take that as a tax credit on their quarterly payroll tax return. So essentially, you may be fronting the money, but you're made whole at the end of the day.
Thank you, Alan.
You're welcome.
So Ken, I'm curious, what is it that you are hearing is of a concern to the clients that your law firm serves, especially because during this quarantine period, a lot of general types of surgeries have been postponed. So what concerns are you hearing, and what suggestions do you have for consumers?
We can't hear him.
Ken, we need you to unmute your microphone.
Sorry.
There you go.
Apologize. It's been interesting that during these 6 months, we've not actually seen a whole uptick of what I would call direct COVID-related claims. In other words, people that have something that's happened to them that they're directly associating with COVID. And there's a bunch of reasons for that, we think. Number one, at the outset, people weren't sure where any of this was going, what to do, what not to do. Secondly, when this started back in March, at least, I think people looked at this as though no one was really sure even what the healthcare providers were supposed to be doing at that point in response to this, because everyone seemingly was caught off guard and unprepared for this. So what we've anticipated is that as time moves forward and people take a look at this situation, what they're going to wind up finding is that there are other types of claims that are going to arise, not directly because of COVID, but things that didn't get done because of COVID. People that put off visits, doctor's offices that, closed for the period of time, and for whatever reason, people didn't get their results on time. Testing isn't done. There's not follow-up appropriate. We think there's going to be an uptick in those types of claims because of the fact that once people realize that they're past this initial crisis period, they've overlooked some of these other things. We think that's likely going to lead to additional people looking at claims. The advice that we give everybody, whether this is COVID related or not, is if you've had an encounter that you've had a result that you've not expected, is not good, is not what you were told to anticipate, explore your rights, right? That's when you need to be calling a lawyer to take a look at this. You may very well be told, look, there's no claim here, right? Especially COVID related. There's going to be issues about, if people did wind up trying to make a claim over that, can you prove how you contracted it? Was it somebody's fault? There's so many unanswered questions in this field that the influx we think of claims is going to come in the next 6 months. They've not actually started thus far. From a practical standpoint, the impact it's had on existing claims is obviously with the lack of jury trials, it kind of puts a crimp in getting these cases to conclusion. Insurers in general at the outset, for smaller cases, seemingly were trying to resolve cases during this period of time. Part of that, I think they were trying to take advantage of people who were looking to settle cases because they needed the money. But what we have found is that time has gone on without a trial date available, especially malpractice cases, which tend to be larger value cases. Insurers are kind of putting their hands in their pockets right now and saying, I don't have the threat of a trial date. We're going to wait and see how this goes, and maybe we'll talk to you next year. So there's different impacts on the clients. There's different impacts on the cases. And we think that all of this is going to come to a head over the next 6 months as opposed to what's already occurred.
Ken, would you share with us some of your firm's insights for people that now are considering going forward with an elective type of surgery?
It really depends on people's personal comfort level, right? We've got people that are taking the position that they're not comfortable at all going into hospitals. They don't want to do any type of elective procedure. We've got other clients who are saying, you know what, just as people have different views on this, that they're more than willing to go in and they think that it's safe and they're prepared to go forward. We know the hospitals have not fully gone back to the way it was before. And what I mean by that is they're still limiting the number of people that can come in. If you're admitted for any reason, the number of visitors you're allowed, there are still restrictions in place. So it's not so much a steadfast rule, it's really personal comfort level as far as what risk you're averse to or not averse to versus how badly you think you need the procedure. Obviously, people that have, and I'm just using an example, cardiac conditions, if a doctor says you need a cardiac catheterization, while that may not be an emergent procedure, it's pretty urgent, and those are going forward. But, people that have, some type of minor procedure, finger injuries, things like that. I know a lot of people that have put things off like that just because they don't think the risk merits that type of outcome.
And do you have any guidance for people that are at this point where they're entertaining how badly do they need the procedure or surgery? What should they be looking into? Should they be looking into the background of the doctors they've consulted? Do you think they should be finding out from the hospital where they might go for rehab? Any suggestions?
It really, kind of like what Alan said in the employment standpoint, it's really a communication issue, right? The patients need to really be working with their individual healthcare provider for that type of information. It is not easy getting information out of hospitals about, here's our rate of this, here's what we do, here's where we send people. They're going to typically refer you back to your own physician. So if you have a physician that you're comfortable with, your first line is to go to that physician and speak to them openly and frankly and make your decision based upon their guidance. They're really going to be the person that gives you the most insight as opposed to looking up some other source.
good suggestion. You mentioned a couple of minutes ago that if somebody goes through a procedure or a surgery and their outcome is not what they expected it to be, that's the time for them to reach out to you and your firm.
Correct.
Before they do that, are there other things they should do? For example, should they be taking pictures? Should they be documenting like in a diary?
We don't necessarily encourage people to do that. We don't discourage them from doing that. And every case is individual because it depends on what the scenario is. If it's the type of thing where, and I'm just using surgery as an example, if you've had a surgical procedure and you have a scarring problem that you're concerned with, or the healing didn't go right, well, then pictures may be helpful in that scenario. But other types of things that may not really be of any value. What we say is this: go to your doctor, let them guide you. When you think you've gotten to a point where they're no longer answering your questions or being able to give you the information you need and you're looking for answers, that's when you consider either consulting with a lawyer who can look into that for you, or at least getting a second opinion from another physician before you do anything else.
Thank you, Ken, for sharing your insight today. Next, we're going to hear from Ido Alexander. Ido, are you seeing any trends these last few months as we watch people struggling financially and now facing new types of debt that previously they would have been able to handle?
So a large portion of it is, excuse me, a large portion of the debt is really small business owners that are contending with their landlords. Those are business guaranteed debt that they otherwise, their business is failing, and now they need to figure out what they're going to do. And the primary debt that they have to deal with is that guaranteed debt. The problem that arises right now is the uncertainty. And I think that Ken had mentioned the uncertainty in the next 6 months of what's going to happen. I believe that the biggest factor here is what's going to happen and how do we deal with it. There are many tools that in my world, the bankruptcy world, that bankruptcy does provide. The issue is trying to determine when is the right time to file a bankruptcy in order to help the individual deal with that kind of debt. We are so fortunate actually that during the inception of this crisis, Congress passed the CARES Act. And the CARES Act provided many useful tools, changed certain laws, bankruptcy laws, to make it easier on both businesses as well as individuals to deal with these kind of debts. But the problem is, it's the timing. In filing a bankruptcy, we're effectively hitting a reset button of sorts. The issue is, what do you do with that reset button? If you're reorganizing your business and you're hitting the reset button, the question is, where's that revenue for the business going to come from in the future, and how do we accurately forecast and predict and set forth a projection for that business? In these times, especially, I'd say in the initial few months, back in March, April, May, it was much harder. Now it's becoming less difficult, but still there are challenges involved in predicting what's that projection for the business. On the other hand, for the individual, hitting the reset button, there is an issue, which is if you hit the reset button before the individual has a stream of income that is sustainable, then you may have hit that reset button too early. And you may be able to discharge the debts, but then find yourself with an individual that will accrue more debt in the future. So it's really a struggle as to the timing of when to do things. But we're fortunate that, like I said, as we're moving forward, we're going to start seeing a lot more individuals and a lot more businesses take advantage of the bankruptcy laws that are out there, especially the new laws that were provided for by Congress under the CARES Act.
So Ido, tell us more about these new tools that are available to consumers and business owners.
So we're actually fortunate in that back in August of 2019, Congress passed under the Farm Bill a new type of Chapter 11, a new type of reorganization for small businesses. They passed it. It came into effect February, and then COVID and lockdown came into sometime around, I believe it was March 20th. So when the CARES Act was passed, they quickly scrambled to put together a package for the whole country. And you could look at it as a package that is sort of two facets to it. One was what everybody heard in the news, PPP money, EDO money, the money that just flooded the market, uh, workers' compensation, unemployment, everything under that package. And a second portion of it was the amendment to the bankruptcy laws. So what they did was they had this new tool called the Small Business Reorganization Act, a new type of Chapter 11, which is faster, cheaper, with less reporting requirements, which was great. But the barrier to entry was for small businesses that they couldn't have more than $2.725 million in debt. When they originally passed the law, the congressional testimony had provided that if businesses, most businesses, 90% of businesses in America that go into bankruptcy have less than $10 million in debt. So even though through political maneuvering they ended up at 2.725, they quickly realized when COVID happened and CARES Act was being passed that they need to increase this debt limit in order to take advantage of this new law. So they increased it for 12 months. There is a sunset clause in it, which allows businesses to take advantage if they have debts less than 7.5. So you see, they went from 2.7 to $7.5 million in debt. So now a lot more businesses can take advantage of this new law. On the individual consumer side, they provided for those who are under a Chapter 13 payment plan. That's a type of bankruptcy where the debtor pays their debt through a plan over 5 years. They modified that and said, if you are already under this plan, you can extend it for up to 7 years instead of 5 years, which is a major advantage. They also modified the calculation of how much money is dedicated towards the plan under a Chapter 13, and the calculation as to Chapter 13 versus Chapter 7. Those are the types of bankruptcy that are available. Plan of reorganization for an individual under Chapter 13 versus liquidation. They amended the calculation and excluded out of the calculation income that is derived from government assistance, primarily unemployment. So when the courts and the calculation is looked at, they meaning those that are reviewing the cases, cannot look to government assistance as a form of income to support the plan of reorganization, the Chapter 13 plan of payment. So the CARES Act provided major useful tools. The problem as it stands today is that there's a disparity here between what is reported in the media versus what's happening in reality. And the disparity is the media is, we're constantly hearing news about large Chapter 11 bankruptcies that are happening. And it creates a false perception, especially in the public, that there's a flood of Chapter 7, Chapter 13 consumer bankruptcies, there's a flood of small business bankruptcies. Unfortunately, because of the challenges that I described earlier about prediction and how to plan, that reality is not really there. What's happening there is right now is that everybody's pretty much on the fence. I mentioned the large quantity of money that was provided for under the CARES Act. That money is right now supporting a lot of small businesses and a lot of consumers and individuals that are effectively sitting on the fence and not taking a decision that they may need to down the road. The expectation is, without looking for a glass hole, is sometime in Q1 2021, that there will be an increase of consumer bankruptcies as well as small business bankruptcies that could take advantage of these laws.
When we were listening to Ken talk about his area of practice, he mentioned that currently there are no trials being held in his area of medical malpractice. What's happening with hearings in the bankruptcy court?
I will say, if there's one thing that I'm very pleased about, is the fact that everything has gone digital. A large, substantial portion of hearings are either held telephonic, if it's morning calendar, short, small issues that can be resolved over the phone. Evidentiary hearings are done through Zoom. About a week ago, I had an evidentiary hearing scheduled through Zoom. And I have heard of limited instances whereby practitioners demand to be physically in the courtroom. And under those circumstances, special accommodations were provided, whereby what I understand is that they provided one attorney from each side to be present in the courtroom, with the rest attending via Zoom. But I would say overwhelmingly everything has gone to the digital age. And hopefully, my opinion would stay that way.
So it sounds as if a new client were to come to you for advice and you determine the appropriate time for them to file, whether it was for a consumer or a small business owner, that they would actually be able to complete the bankruptcy process while all this is going on.
Yeah, not only that, it's in fact, there was a judge, he has since retired, that issued a very scathing opinion of the notion of the requirement of an attorney, and this happened back in February or January of this year, where a practitioner did not execute the bankruptcy schedules with the client, did not actually provide a wet signature on the bankruptcy schedules. And the requirements at that time required actual wet signature. And practitioners were everybody was talking and saying, how is it possible that in the year 2020, you can't do a DocuSign on bankruptcy schedules? Well, today, as you indicated, Stephanie, a client can basically do everything virtually. Anything from our initial consultation we're conducting through Zoom. We execute the schedule. The client executes the schedules through DocuSign or comparable commercial services. They will attend their meeting of creditors after the filing. The filing has been done for many years now online, but after the filing, they will attend their meeting of creditors. Instead of in person, they will do so on the phone. Any hearings will be done through Zoom. So if anything, it's streamlined much of the process. And I think long-term, whether it be bankruptcy, also other practice areas, I'll defer to my colleagues on this panel, but I believe there's going to be substantial savings to clients long-term from the fact that they're not paying. Clients do not have to pay for an attorney to appear at a hearing for 2 hours, when in reality, that hearing, in the net amount, is probably somewhere in the order of about 15 to 30 minutes. So overall, I'm very enthused, as you can see, about the evolution and the impact of technology on the legal profession, and how it's forced us to adapt quickly. What would have taken, I think, years, if not a decade, to transform in that direction.
Well, it sounds like things are actually having positive outcomes. Hearing from you that your area of the law has become more efficient.
Absolutely, absolutely. But
Well,
I'll ask my colleagues on the panel, do you think it's gotten efficient? And I'll direct it to Nancy. She's nodding.
Well, for sure, I feel very similarly to Ido regarding the effectiveness of everything in family law has continued to move forward really seamlessly. We're fortunate in family, much like in bankruptcy, we don't depend on juries. So everything is a bench hearing or a bench trial. And what we have found is that the courts in Broward County in particular was a shining example to the rest of the state, where almost no time was lost in Broward County. I think only maybe in that very first week, if you had something right when the shutdown happened, but within about a week, Judge Tudor and all of the family judges kept moving everything forward. We've had trials, depositions, mediations, all via Zoom, pretty seamlessly. And they are going to carry the ability to appear in hearings by Zoom forward, even when in-person court is available again. I can't anticipate going to motion calendar ever again in person. So much time was wasted. While I enjoyed the networking, the socializing, we called it the social hour on the 11th floor, a lot of time was wasted. And for someone like me, whose office and home are a good 35 to 45-minute drive to the courthouse, I'm saving an enormous amount of time.
So Nancy, I would imagine that in your area of the family law practice, you are working with clients who are dealing with very sensitive issues. They're emotionally charged. The end of a relationship is affecting them psychologically. When you look back at the last 6 months and you see the number of businesses that closed, people were laid off or they were furloughed without knowing when they would have a paycheck coming in, how did that affect families as a whole?
Well, certainly the phone started ringing with current clients who immediately wanted to let us know that they had suffered a job loss or a layoff or their business. This is an issue in a number of pending divorces where pre-COVID, there was no question that it was an alimony case, and the only questions to be answered would be how much and for how long. And now we're having to almost reserve the issue of alimony for later determination or doing it on a temporary basis because the circumstances that the family is in right now financially in terms of their income is down. It's been severely impacted, but the hope is that that impact is going to be temporary in nature. So it is affecting the way we practice law in terms of how we resolve cases for the unfortunate few who have to go to trial in a divorce. The court can only make decisions based on the facts as they are on the day of trial. And I think you would end up seeing a lot of nominal alimony awards, which is the placeholder for alimony when alimony would otherwise be appropriate, but for some reason there's no current ability to pay it. And we have had this concept of nominal alimony for a really long time, but we're seeing it used almost constantly in the last 6 months because of this very fact of COVID and the loss of income. So from the income standpoint, there have been tremendous impacts in family law cases and how they get resolved and how they get decided in court. In addition, people who have frequently disagree on all kinds of issues related to their kids, and COVID threw many issues into the mix, including parents who thought that they should have the right to control how the other parent handles their life and wants the other parent to follow the same sort of, we'll call them COVID rules or quarantine restrictions that parent followed. And it should come as no surprise to anybody that when you're dealing with a couple that is doing, or even if they were never married, it's even worse for couples who were never married and didn't live together. There's no common sense of mission at any point in the relationship, and they don't agree on, you had people withholding time sharing, There was a very newsworthy case of a doctor who, a Miami judge, basically temporarily without a hearing modified the time sharing because that parent was a physician in a hospital. That got overturned on appeal pretty quickly, but the issues continue, and you now have the issues of parents having to adjust to school situations with online learning, accessibility to internet, whether a parent is working from home or not working from home, who's home with the child. All of these have impacted family law cases with children because A, parents never agree and or rarely agree, and B, the COVID has thrown new issues that they were ill-equipped to handle.
Are there any recent decisions that you'd like to share with people who are listening to the webinar today?
Well, more than decisions, I think we should listen to what the trial judges are saying, because other than the one case out of Miami that got so much attention because a judge basically yanked a parent's time sharing, and this was back in the spring, the judges in all of South Florida have made it clear that they expect court orders to be followed, and that invoking COVID as a reason not to follow a time sharing schedule is not going to go over well with a single family judge in South Florida that I have heard from, and I've heard from many of them. They expect the orders to be followed. If you are having a problem with a court order, self-help is never approved of by your trial judge. So you should expect to file a motion and seek court intervention without engaging in self-help. Nevertheless, people engage in self-help, they'll file the motion and they will withhold the time sharing anyway. Some parents are doing it in the best interest of their children. You do have situations where a parent literally has been exposed, has been reckless, disregarding even the most basic recommendations, and parents have withheld the child and simply offered makeup time. Since makeup time is really the remedy for time sharing being withheld, it's probably the only way to try to navigate it until you get a court hearing, if you literally have a parent who is outright exposing their child to the virus. So I think you have to differentiate between a parent who is literally endangering a child versus they're just not doing things the way I want them to do them, and reasonable people can disagree on certain things. But I think judges are finding that you know, you can't disagree on certain things, and taking your child to a gathering of hundreds of people is never going to be okay in anybody's mind.
That's good advice. Nancy, what are some of the tools you use in your family law practice, even when we're not in a pandemic like we are now, to try to bring people to work together for the benefit of their children?
Well, I think the two biggest tools that we have are mediation and collaborative practice. Keeping families out of court, convincing our clients that taking your chances in court is never a good idea, and going to court itself and having a judge decide your case really should be the route of last resort. And most cases, especially when we're talking about initial proceedings of divorce or custody for unmarried parents, leaving aside issues of enforcement and modification, because modifications are always more difficult to resolve because people are resistant to change. It's not a secret that people like whatever it is they've had, they've gotten comfortable, and when one parent wants to change the schedule, that's a whole different dynamic. But when we're talking about initial proceedings of divorce and parentage, it is almost never advisable to go to court. it is almost always in the family's best interest, short of the very rare scenario of significant mental illness, significant personality disorders that just make any type of agreement, negotiation, or discussions impossible. But that is such a small percentage. The overwhelming majority, and I'm happy to say in my office, more than 99% of all original proceedings are settled out of court. And mediation is better than court, but it's not as good as a collaborative practice where the parties are actually empowered to express what their own concerns are. They're empowered to negotiate directly and to learn to speak directly to the person that they are no longer in an intimate relationship with, because these people are going to be on a common mission to raise children. And if they don't ever learn to start communicating with each other in a constructive way, much like you may work with people at your firm that you don't particularly like, and you might not want to socialize outside of the firm. You might not like their politics, the way they run their life, but you have a job to do and you need to do it. And co-parents need to learn that their job is to raise their children together, and even though they're separate, and to do it in a way that minimizes the conflict, because longitudinal studies have shown that it isn't divorce and separation that hurts kids, it's conflict. And collaborative practice for sure gives parents more of the tools to learn how to do that than either mediation or litigation. Certainly doesn't give them any tools. It makes us their entire mouthpiece. And if I'm litigating, I'd rather my client never have to speak at all. Let me do all the talking. But in a collaborative practice, we're literally teaching and modeling for these parents how to disagree in an agreeable way, in a polite, respectful, constructive way, and how to problem solve. And we literally demonstrate the problem solving skills as part of the process. And it's highly successful. Florida's got over a 90% success rate in resolving cases using the collaborative model.
That is really good to hear. Again, it sounds like there are definitely positive outcomes from everything we're going through, and this collaborative approach really empowers people. And that's what today's webinar is all about, is how can we help empower people to know that there are tools that they can use. They are going to not only get through this, they're going to surpass it. They're going to do more than just survive. So let's hear about some of the ideas that our panel has for our listeners today. Alan?
Thank you. Just on a going forward basis, from my perspective in my world in which, I represent businesses of all sizes, is again, I think one of the common themes that we've heard throughout from all of my colleagues is open lines of communication, and employers and employees having that open dialogue, for employers to provide a safe working environment. People are nervous. Some people are nervous about coming back to work, and having an environment that is safe, and that may mean the employer providing PPE, personal protective equipment, and being able to accommodate different people's needs. So I think this is an era right now where flexibility is really important. I think businesses' reputations will turn on how flexible the employer was in working with employees during these times, and having a good or not so good reputation going into the future. So I would just emphasize communication, working with the employees working with their employers as well. You sometimes see abuse on both sides of the equation. When I say abuse, in terms of trying to take advantage of, either existing or now some of the newer laws. And again, this is an area of law as it relates to COVID in every profession that's going to continue to evolve. We don't know exactly what lies ahead or the timeline for vaccines and the like, and therapeutics. So I think it's essentially important to have good communication and flexibility at these times.
Thank you for your suggestion, Alan. Ken?
From my area of practice, I think the biggest thing is that people in general need to really become engaged in their own healthcare. And that may sound like an obvious statement, but in a lot of ways it's not. You know, we live in an area down here with a pretty heavy elderly population. And a lot of the areas that we see problems are people that simply don't have someone to go with them to the doctor, someone to ask questions for them, someone to figure out what's really going on. What is the plan? And I think COVID has made that even harder because of the fact that people that have had to be hospitalized have basically been separated from their families. You know, you haven't had visitors go in, you haven't had family members, people you would otherwise rely upon to get the information you need to make important decisions. We've got to figure out, and what we try to encourage people to do is put themselves in a situation to do that. If you've got a loved one that's in a hospital, for example, right now your only choice may be to be on the phone. If you've got to be on the phone all day to get somebody, that's what you need to do to try to help these people and get the information. And then ultimately, obviously, if you've gotten to a point where you don't have answers, that's where we feel like, you know, us as lawyers can be helpful because we can get involved in the process at that point. But it's really a function of becoming even more engaged in your own care, I think, is a big key right now.
That's a great idea. And, you know, today we're trying to empower people. We want people to learn how to be strong advocates. And Ken's right, the natural support system, not that it's not present, but people are challenged trying to work, stay home, take care of kids, and take care of a loved one who might be in the hospital. So one of the suggestions I have for people that are in that type of position is to work with a life care manager. These are social workers and or nurses that have a lifetime of experience being medical advocates. And as a healthcare worker, they can help cut through a lot of the red tape. And since the governor about a week and a half ago has started to slowly lift restrictions for people to be able to go into facilities, I do see that life care managers are going to be more important now than ever to help individuals as well as families navigate through the healthcare system. Ido, what closing remarks would you like to share with our listeners today?
I'll adopt Ken's word, engage with counsel, competent counsel. Don't dig your head in the sand. When there are multiple creditors reaching out and trying to either sue you, demand money from you, now to pretend that it doesn't exist because there's a little bit of money on the table through government assistance, now is not the time. Now is the time to start strategizing and figure out what is the path ahead. The longer that somebody delays and doesn't engage in their own financial situation, the worse off it's going to be down the road. And they're going to do the essential thing that most people do, which is react rather than pre-plan and act in a deliberative fashion. So I guess I leave with one note, which is don't react, but rather pre-plan and act in a strategic manner.
That's great advice. Nancy, what positive thinking tip would you like to share with our listeners?
What I'd really like the lawyers and others who are listening to this to understand is that there is more than one way to skin the cat. Never think that there's only one way to get to the finish line in a family law case. Consider attorneys who practice a multidisciplinary approach. I am not the only attorney around who does both litigation, mediation, and collaborative practice. Some lawyers have given up litigation entirely, and for those of us who litigate, we certainly understand why some people choose not to subject themselves to the stress of preparing for trials. And certainly it's something I have in reserve, but as I had said before, in initial proceedings, I try to avoid using those skills at all costs, mostly because they're never in the best interest of my client, and they're not in my client's best interest even when it's our only option, because it does take two people to agree, and it only takes one person not to agree to end up in front of a judge. But to remind people that there are options, and instead of just wondering, what am I going to get out of my divorce? Am I going to keep the house? Am I going to get alimony? How long? How much? What's child support going to be? What kind of time sharing plan am I going to get? Instead of thinking about the actual outcome that they want, they should spend at least as much time thinking about how they want to get to that outcome. What do they want the process of getting to that outcome to look like? Because there are choices, and most people don't realize that they have a choice in how they get to that. I've almost never met a client who said, I want to see the judge. I want a trial. I want to spend $25,000 or $50,000 taking depositions, hiring experts, being stressed about court dates. I can't wait to pay for your next 3 vacations. I've never had a client want that. Almost every client wants to keep their case out of court if they can. So encourage people to follow that guidance and to find an attorney whose skill set and whose values align with what the client wants. I actually spoke to somebody recently who said, I kept saying I wanted to settle, and I'm talking to you because I'm not really happy with my attorneys, because my attorney said that we shouldn't even discuss settlement, but that we needed to go to a temporary relief hearing. But my spouse and I live together, and he's actually paying all the expenses right now. So I'm not really sure why they think we need to go to court on temporary relief. And I said, whether you hire me or not, listening to what you're saying, what you want is not aligned with what your attorney is doing. And if what you want is a voice in how this works out, you need to hire an attorney who's going to listen to you, rather than saying you need to either do it my way or there is no other way. You have the wrong attorney if the attorney won't listen to what you want. And if what you want is, listen, if we can't reach an agreement on my terms, we're going to go to court, that's a totally legitimate position. But to simply say, well, I'd really like to try to just negotiate a deal, and to have your lawyer tell you that that isn't an option, it's always an option. And keeping your matter out of court is almost every client's first priority. And it should be given a lot of deference by the attorneys.
Thank you, Nancy. You know, I heard both Nancy and Ido say something that's very important, which is that you don't want to be reactive. Because when we're reactive, we're most likely not thinking clearly. We're not seeing all the options that are in front of us. Nancy talked in terms of having choices. And so I share in that advice that they're sharing with our attendees today. And I just want to add that we have choices, but we have to plan for them. A lot of people were caught off guard when the state closed down, whether they were living in private homes, they were living in facilities or senior residences, and they were caught off guard because they hadn't done any legal planning. They didn't have legal documents to name somebody to be a financial decision maker or even a medical decision maker should they become sick or incapacitated. And unfortunately for those individuals, families were left with no option other than seeking a guardianship in court in order to be able to legally make those medical and financial decisions for their loved one. So I encourage everybody who's listening that it's not too late. You can still get your powers of attorney in place, your medical advance directives, and there's very creative ways for doing it. Ido talked a little bit about how we're all using technology more efficiently. Attorneys are doing consultations through video. There are creative ways to conduct the document signings so that everybody stays healthy and safe. So this is a great time. If you haven't already put your legal documents in place, please do it now, because then you're going to have all those choices and all the options that our panelists have talked about today. And if you yourself aren't able to carry out the decisions, at least you know you've put somebody that you trust, who's responsible, in a position to legally make those decisions for you. So I'd like to thank both our panelists today as well as everybody who's listening. I hope that you will continue to join me each month for my webinars. You're welcome to go to my website, www.fl-elderlaw.com, to the calendar page and register for an upcoming webinar. If you'd like to watch today's recording, you'll also be able to see it on my website under the resource page. So we all wish everybody who attended today a very healthy and happy New Year. Stay healthy and take care of yourselves. Thank you for being with us.